We have a major new action by the Supreme Court having to do with redistricting, coming, of course, at a time where we see Texas trying to have a blatant power grab, trying to redistrict in order to gain more seats in time for the 2026 midterms. I'm going to get into what exactly is happening. It is possible that the Supreme Court may try to dismantle Section 2 of the Voting Rights Act. My name is Dina Doll with the MeidasTouch Network. Let's get into this. So those of you who follow Unprecedented, the Supreme Court focus show I do with Michael Popak, you heard us break down this oral argument this past term. The Supreme Court heard a case regarding redistricting out of Louisiana. The Supreme Court, however, never decided the case at the term. They instead asked for more oral arguments, and they will be rehearing the case, essentially focused on one specific issue during this next term. The problem with all of this is the case regarding Louisiana had to do with how Louisiana redistricted after the 2020 census. Both Alabama and Louisiana redistricted in a way which basically diluted Black voters in both of those states in violation of Section 2 of the Voting Rights Act, which says that you cannot deny somebody the right to vote based on race. In Louisiana, they had, after the redistricting, only one majority Black district, despite the fact that the Black voters constituted 1/3 of the voters there. So they failed. Civil rights groups sued them and said this is a violation of Section 2 of the Voting Rights Act. Louisiana lost in court, and they then had a second majority Black district. But after the second one was drawn, they were sued by white voters saying that this was a violation of the 14th and 15th Amendments of the Constitution. The Supreme Court decided to take this case despite the fact that they had already just taken the case regarding Alabama in 2023, the Milligan case. It was essentially the same arguments, and they sided there with the redistricting that was allowing for more majority Black voters because they found that the state had diluted the Black voters in violation of Section 2. So Alabama had to do an extra district. And so there's no reason for them to take on this case. Well, during oral arguments, Justice Kavanaugh said that he believed that Section 2, this taking into account race when you're redistricting, should have an end point. Now, this is the same man who said he believed when he overturned Roe in the Dobbs decision that states should be left with such a fundamental civil private question as to whether or not a woman should have a right to choose whether or not to abortion. This same man thought there should be an end point to whether or not there is a congressional statute, the Voting Rights Act section, to protect you from illegally diluting your vote based on race. So basically, the Supreme Court punted. They decided not to decide at all. Justice Thomas, in his dissent, very clearly said he believed that the Supreme Court should have decided this right away, that voting questions are essential and why the delay. And he, in that dissent, makes it very clear that he believes that Section 2 of the Voting Rights Act is a violation of the 14th and 15th Amendments. The 14th Amendment, you cannot discriminate. We all have equal rights under the law. And the 15th Amendment very clearly says that your right to vote cannot be abridged based on race. So the question presented to the Supreme Court didn't have this question of whether or not the Section 2 violated the 14th and 15th Amendments. That was just added. We just got the Supreme Court order who said, hey, parties, I want you to specifically look at pages 36 to 38 of the brief submitted by these white voters. And sure enough, if you go to pages 36 to 38, they are questioning the constitutionality of Section 2 of the Voting Rights Act, meaning the Supreme Court is seriously considering overturning such a bedrock protection of the right to vote. We, on August 6th, are marking the 60th year anniversary of the Voting Rights Act. We saw what happened in the Supreme Court decision, Shelby, where the court decided that the federal government no longer needed to pre-clear changes to voting rights in certain states. Before it had been that a certain states that shown discriminatory nature toward voters would have to submit any voting plans to the federal government to approve it. The Supreme Court said that was no longer needed, and they overturned it. And that's where Justice Ginsburg famously dissented, saying that if you are in a rainstorm holding an umbrella, but you're not getting wet, you wouldn't throw it away. Essentially saying the whole reason that things are doing well is because of this Section 4 of the Voting Rights Act. But they decided to do away with it. This is why we have seen since then the voter purges, the closing of voting polling, so many more, the voter ID laws, so many more actions to restrict the right to vote. There is no more fundamental right in this country than the right to vote. And Republicans know it. They know they cannot win on elections alone. And so they work to try to restrict the right to vote. So here we have the Supreme Court already willing to gut the Section 4 of the Voting Rights Act. They just, though, in Milligan, again, in Alabama, upheld that Section 2 of the Voting Rights Act. It was a 5-4 decision. The liberal justices plus Chief Justice Roberts and Justice Kavanaugh formed the majority. But Justice Kavanaugh did not form a specific section having to do with how to view a map, whether or not you look at the intent or the motivation. And based on his comment in that oral argument, saying that he believes there should be an endpoint to this, we may very well now have a new 5-4 majority if Justice Kavanaugh switches that would allow for the striking down of Section 2 of the Voting Rights Act, which would essentially mean it would be a free-for-all throughout the country in Texas and elsewhere for voting rights to be diluted, because Section 2 protects against the dilution of your voting right. So this could be a really scary kind of coming together between what Texas is doing and the Supreme Court. I'm excited about this new sponsor because they make cooking pans that I have come to love. It's called Hexclad. This is just one of the ones I have. It's a 12-inch saute with a lid. And I think I make most of my meals in this pan because the lid makes it cook faster. The saute is easy. And the thing that I love about this brand is that you can use utensils actually, because a lot of nonstick coatings, you have to be really careful about what you use. And most of my family just use whatever. And so the nonstick gets scratched. And then once it's scratched, you don't feel safe about using it. So I was really excited about the fact that this is a hybrid. It's a stainless steel plus their proprietary ceramic coating, which is nonstick, but you can even use utensils on it and not scratch it. That is huge for me. Plus, it's dishwasher safe. Another big requirement in any pans for me. So it doesn't have all those kind of awful chemicals from nonstick, but it sears like stainless steel because of this hybrid function there. So it is really exciting. I have this plus the wok they make and some of their other pans. So I was really excited to tell you about this because I've gotten really excited about it. And not only do they have pans, but they have knives. They have Japanese Damascus steel knives. So with these knives, you can slice through food so easily. I know during the summer, a lot of people are having family over or friends over. It's a time that you're going to be probably cooking a lot more. So these knives are incredibly sharp. They're balanced and they just are really easy to use, making all the prep work that much easier. So much so that a renowned chef like Gordon Ramsay trusts Hexclad. That to me speaks volumes about their quality. Not only have I enjoyed their quality, but obviously a chef like that enjoying it is huge for me. They also have a lifetime warranty on their pieces, which makes you feel even more comfortable about using it. So summer is the season for effortless gatherings and delicious food. So why not treat yourself to the best cookware and knives to make it all a breeze? For a limited time only, our listeners get 10% off your order with our exclusive link. Just head to hexclad.com/mistrial. Support our show and upgrade your summer kitchen at hexclad.com/mistrial. hexclad.com/mistrial. Make sure to let them know we sent you. Cheers to stylish and stress-free summer hosting with Hexclad. Perhaps what Texas is doing may give the Supreme Court pause. That could maybe be a silver lining, and they don't want to go as far as they would otherwise because they see what is happening in Texas and they don't want a free-for-all. We'll see. But Justice Thomas, I thought it was a very interesting dissent because he clearly thinks he has the votes because he said we shouldn't have punted. We should have decided this now. I don't think he would have said that if he didn't have the votes, because if you would want more time to convince the people who aren't on your side. So he thinks he has the votes. And he's saying, let's do this now so they can make the change in time for the 2026 midterms. Because the problem is these briefs, they've set out a briefing schedule and the last one isn't due until like the beginning of October, like October 3rd. So this opinion is not coming out anytime soon. And you are going to start hitting primaries in states. And so there's something called the Purcell Doctrine, also from a Supreme Court decision that says courts shouldn't, kind of tinker with, let's say, election rules and election laws too close to an election. So they're going to come against their own doctrine, and most likely they will have to, even if they gut the voting, the Section 2, it won't be in time for 2026. It would be in time for 2028. Still a really bad outcome, but perhaps that is why Justice Thomas, thinking he has the votes, didn't want to delay it and wanted this to go now so it could become in effect in time for 2026. But my hope is that the more Governor Abbott just blatantly tries to steal seats, and frankly, the more blue states like Newsom says, hey, we're going to do the same, perhaps it might give the Supreme Court, Kavanaugh or anybody else, Gorsuch, I don't even know who out of them are good. Barrett sided with Thomas in the Milligan dissent. So it's unclear if anybody can be persuaded, but perhaps the messier it gets, the more combative it gets, perhaps the Supreme Court will stand on the side of some sort of normalcy and protect the right to vote of minorities in this country. My name is Dina Doll with the MeidasTouch Network. I'll be sure to update you on this case and others. So free subscribe if you haven't already.
The truth is more important than ever. Check out our new Truth Over Lies collection at store.meidastouch.com. All 100% USA union made.